Good morning, everybody. This is Dan Bouchard with Remax Realty Group's DC office. Want to welcome you today. This is a class on how clients and customers deal with real estate agents, and in Washington DC itself. And so we're going to be talking about the nature of the relationships that agents have with the consumers. So we're going to jump right into this, and we are going to share my screen. And if you've got any questions ever that you need to have addressed, feel free to reach me at my email address, which is adb@goodvibehomes.com. Vibe is singular, homes is plural. Thanks so much. And let's just jump into our lesson for today. All right, and I believe that I am sharing my screen, and so we are going to go ahead and jump in. So when we're talking about real estate in DC, it is governed by DC law, which is Title 42 of the Code of the District of Columbia. And so when we go to the website for the City Council, the laws are detailed there and described in great detail about what the nature of a relationship with a real estate agent is. And so let's go ahead and start out, and it can be found here, but I'm going to go ahead and for the time being, we're going to use a copied version of this so that we can focus on the important elements that we're going to talk about today. So the whole purpose of what we call agency, which is the relationship between consumers and real estate agents, the primary purpose is to protect the public against incompetence, fraud, and deception in real estate transactions. And that's copied directly from the code. So that is primarily the purpose of it, and the intent of establishing these rules. And we live by a code of ethics also for those of us who are realtors. And so we will, and those complement to a great extent what we are dealing with. So when we're talking about the relationship in general, we're talking about what is called agency. And the term agency means every relationship in which a real estate licensee acts for or represents a person by such person's express authority in a real estate transaction. And so it is just the means by which we have authority to act on behalf of a buyer or a seller or a tenant or landlord in Washington, D.C. And so that's where that goes. So then the next part of this is we talk about a real estate licensee who enters into a brokerage relationship based upon a written contract, which is specifically states that the real estate licensee is acting as an independent contractor and not as an agent, as an independent agent, and shall have the obligations agreed to by the parties in the contract. So a real estate agent cannot engage in a buyer agency agreement with a consumer by themselves. They must do so under the supervision of a principal broker, or otherwise known as a broker. So let's use, for the purpose of our discussion, we're going to talk about a big B broker and a little b broker. So DC law defines there are two types of real estate license, well, three types of real estate licenses. There is a broker license, there is a salesperson license, and there is a property manager license. When we're talking about buying and selling real estate and representing landlords and agents, landlords and tenants for the purposes of buying and selling or renting and leasing, the real estate licensees that are allowed to find tenants, find buyers, find sellers, and engage those clients in their relationships can be a broker or can be a salesperson. And so when we work through all of that, that kind of a relationship falls under the direction of a big B broker. And so we're going to talk about, let's say, capital B broker. So capital B broker is a person that has been authorized by the city to be a owner of a company, or the supervising broker that is in charge of that entire company, and all of the agents under that broker are responsible to that broker for the purpose of the supervision of those agents, and making sure that they conduct themselves within the code of ethics and conduct themselves within the DC law. Then there are small B brokers like myself. Okay, I am a small B broker, and in some jurisdictions this is called associate broker, but in DC they call it just broker. It's a universal term that they use. And I work for a principal broker, a primary broker, and that broker has delegated to me the authority to supervise the agents that are under me. That's just I don't like to use it to phrase it that way, but that's the kind of like the pecking order of the way that the law is structured. So there is an accountability up the chain. The agents are responsible for conducting their business in accordance with the law, and it's my job to supervise that, and I have to report to my boss, the big broker, the big B, capital B, and that's where that lies. So when we're talking about engaging with a real estate agent, there's a brokerage relationship that is involved here, and it's designed by the law, and it means that it's a contractual relationship between a client and a real estate licensee who has been engaged by such a client for the purpose of procuring a seller, buyer, option, tenant, or landlord for a ready, able, and willing, who are ready, willing, and able to sell, buy, option, exchange, or rent real estate on behalf of a client, or for the purposes of managing real estate on their behalf. So that last part of that sentence, or for the purposes of managing real estate, that would apply to property management licenses, which I didn't really talk about before. And for the purpose of this discussion, we're not really going to focus on that. That is a separate subject. So let's go ahead and define what is a client and what is a customer by DC law. So there is a little bit of a difference. So the term client means a person who has entered into a brokerage relationship with a licensee. And so what in this case, the licensee that is being discussed is the big B broker. And even though the contact that the client has with the company is primarily going to be perhaps the salesperson or the small B broker, the relationship is actually with the big B broker. I know that can be a little confusing, but anyways, that's kind of the way that is structured. So we're talking about a client who's in a relationship with the big B broker in the relationship, and they're a client. The term of customer means a person who has not entered into a brokerage relationship with a licensee, but for whom a licensee performs ministerial acts in a real estate transaction. So unless a licensee enters into a brokerage relationship with such a person, it shall be presumed that such a person is a customer of the licensee rather than a client. So when we're talking about the difference between customers and clients, customers are entitled to a lower degree of service than our clients. So when we're dealing with customers, we have to be honest, and we have to disclose known material defects, known material facts that that are publicly known and that are that are pertinent to the situation. So we have to be honest. We cannot hide material facts. We have to disclose to them the things that are vitally important. We have to conduct ourselves within the boundaries of equal opportunity for housing, and in every other respect. DC has laws that govern the nature of equal opportunity, and that will apply to everybody that is a customer. But that's about where the loyalty ends. When you're a customer for a licensee, a brokerage, you don't get the benefit of having guidance, advice, counseling, recommendations, and best strategies for the protection of your finances and the protection of your legal interests. You only get honesty and truthfulness and the compliance to local laws and the federal laws as well. So that's a minimum standard there. When we're talking about a client relationship, however, the client relationship is a little bit deeper. And so what we end up doing is you enter into a client relationship by a written agreement. And so as a buyer's agent, I can go ahead and get into a relationship with you as a consumer, and we can then go ahead and have an increased level of service to you above what is in the customer relationship. Everything that's included in customer is also in client, but client has extra loyalties, and basically it just means that I have fiduciary loyalties to you. I have to keep things confidential that we discuss, which I don't have to do in a customer kind of a relationship. I have to keep privileged conversations just between us, and I can't reveal those things to the other side. I have to guide and counsel and coach you through to get you through to getting a successful transaction in a way that will balance the protection of your legal rights and balance the success of the transaction. So, you know, I often say that we can go ahead and write a contract today that is so slanted in a buyer's favor that there's no way a seller will accept it. And similarly, we can also write a contract today for a property that is so slanted in the seller's direction that it would not protect the buyer in any way. And either one of those scenarios is not a successful strategy for getting a deal done. So the way to get a deal done is finding that sweet spot in between there that balances meeting the buyer's needs and the seller's needs, and finds a way to protect you as a buyer if you're the buyer in the situation. I'm using that as an example, but it really does apply to the seller as well when the relationship is with the seller. So if we are engaging in a process and I'm representing you as a buyer, if you're the buyer, I'm representing you, then I am required to guide you with my experience, my knowledge, my training, that will lead you to a successful result to accomplish your goal of buying your property. Same thing goes if it's a seller, it's the opposite way. So, and we do that in a way to make sure that we're looking out for your legal interests and that we are protecting you in as much as we possibly can anticipate. We can't possibly write a contract today that will cover every possible contingency you might encounter as a buyer or as a seller for that matter. But what we do is we try to focus on the main important aspects that are most likely to come up and to not expose you unnecessarily to those risks. And that's the big issue of what we're trying to accomplish today, is we're trying to structure a scenario that protects you, that conserves your finances, your financial position, and that looks out for your future liabilities, while at the same time succeeding with your goal of buying this property. And so that's the whole nature of what we're trying to accomplish. It's a balancing act. And that's where that kind of thing kind of comes into play. So as a client, you get the benefit of my knowledge and experience there. And I use myself as an example here, but this applies to any licensee. You're using, in a client relationship, you're getting the benefit of the knowledge and the experience of that agent to guide you through the process and to a successful transaction in the end. So that's kind of where that is. So let's go ahead and presume, now that we've identified customer and client, we also now have a relationship that also exists where we've got a buyer agency agreement, and that buyer has succeeded in achieving a relationship with a brokerage, and that relationship is codified into an agreement that is a buyer agency agreement. You know, colloquially, we refer to that as a buyer agency agreement or a buyer brokerage agreement. And so that's what that structure is established by. So when we're talking about that, we also have a scenario where a seller is also in a similar kind of a relationship with the broker as well. So a seller will have a contractual relationship with a brokerage in order to get the property sold. And the same kinds of loyalties happen with a seller client as we have with a buyer client. And the same kinds of loyalties apply for a landlord client as there are for a tenant client. We're not talking about property management at the moment. We're just talking about buying and selling or renting and leasing. So that's what that is at the moment. So if, for example, we have a scenario where I am a listing agent and Sally over here is a buyer's agent, and we both happen to work for the same ABC Realty company, then Sally and I are designated agents or designated representatives of ABC Realty, because the broker will have assigned Sally and I to represent our individual clients. That's called designated agency or designated representation. And that's where that is. And so it's a means for a licensee who has been assigned by a principal or supervising broker to represent a client when a different client is also represented by such a principal broker in the same transaction. So the key there is that it's in the same transaction. So Sally is the buyer's agent, I'm the listing agent. We both are representing our respective clients, but the company has its designated agency responsibility. The company has loyalties to both the buyer and the seller, but the individual agents have loyalties to their respective clients. So that's kind of where that lies. And there's a distinction between the two, and Sally and I can't exchange privileged conversations that we have with our respective clients to each other. And so there's a kind of a firewall in between those two relationships. The brokerage, however, does have loyalties to make sure that everybody is treated fairly and impartially. So that's what we call designated agency. When we are in a situation where I am the listing agent and I also have a buyer who might fit the parameter, might fit with the property that I'm representing as a listing agent, or the landlord, the owner that I'm listing as a listing agent, then I can bring the buyer and the seller together into a contract and write that contract up. And I can have loyalties in that situation to both parties, the buyer and the seller, in the same transaction, and have that transaction move forward to settlement. Now, it is allowed by DC law. In some states, it is not allowed at all. In Maryland, that kind of situation is not allowed. Now, I want to make sure that I pause here for a minute and make sure that we understand the definitions that I'm making today are specific to DC law. Maryland law has different definitions for some of these things. And so I don't want you to confuse what Maryland law is versus DC law. However, DC law is very similar to Virginia's law in this respect. So we'll talk about Virginia law tomorrow in the next class that I'll be teaching tomorrow. But for now, let's just focus on DC. So designated agent in the same company, two agents in the same company in the same transaction. Dual agent is myself representing the buyer and the seller in the transaction, the same transaction, I have loyalties to both. So we then get into a scenario where we discover, well, how can you truly represent both of the parties in a transaction and be completely impartial to them? And in fact, that's a really great point, because you really can't completely have fiduciary loyalties to two opposing parties in the same transaction. So when you have a dual agency situation or a dual representative situation, there's actually a reduced level of service to each of those clients, because we can't reveal privileged information about one client that the other client is not entitled to. And so the loyalties that we have still apply, but I can't, if I have some knowledge about my buyer that that is confidential and not material, I cannot reveal that to the seller, or vice versa. You know, things like divorce, things like you know, a bankruptcy that existed in the past, and you know, in a long time, as long as those parties are otherwise qualified for performing in the terms of the contract, I'm not at liberty to discuss those things about the one client to the other client. Hope that's not confusing, but that's basically where we are. So it's a reduced level of service, only because it's very hard to be completely impartial in a dual agency situation. Personally, as a matter of my own business practice, I do not participate in dual agency because I do feel like it is a conflict of interest. However, DC law does allow it. So I wanted to make sure that we understand that. I would prefer to have two independent sets of clients who are very happy with me and very pleased with the way that I serve them and my loyalties to them, than to have excuse me, let me rephrase that. I prefer to have one client that feels very good about the way that I represented them and my loyalties to them, than to have two clients that are feel wishy-washy about the way that I serve them and feel that maybe they didn't get the best possible deal because I had loyalties to both sides. So that's my own personal philosophy. That's not to say that that is the law. The law allows for that kind of a relationship. So when we're talking about this, that is pretty much where we go. So when we're talking about real estate, we are talking about condominiums, leaseholds. We don't need to spend too much time on leaseholds, timeshares, any other interests in land, other corporate or non-corporate freehold, non-freehold, or whether located in District of Columbia or elsewhere. Actually, we're only talking about DC here, so that's the only thing that applies. So the term real estate includes any share or membership in a cooperative organization pursuant to Chapter 9 of Title 29 of the DC Code. to engage in activities related to real estate, even though the shares of membership may be deemed to be securities. And so the reason for this sentence is because when we're talking about real estate, the traditional definition of what real estate was, 100 years ago, really was focused on the land, the improvements of the land that sit on it. And when we say improvements, we mean any structures that were built on the land, the sky above you and the land below you. By definition, that's what real estate was 100 years ago. Around the turn of the last century, a little bit after, just around the time of the Depression, there were two concepts that evolved out of the necessity for affordable housing. A lot of people didn't have the ability to own, to buy and sell, to buy real estate in the traditional sense, where you bought a farm, you bought the buildings, and you owned the sky above you and the earth below you. So they came up with two concepts of creating different kinds of real estate. One of them was a condominium, where you share the expenses of maintenance and insurance and all of these other things. And that was one kind of real estate. And you actually do own your condominium unit when you own that. So that fits into a little pocket of what real estate is. The other concept that they developed was the cooperative. And a cooperative is not actually the ownership of land or of a building. It's ownership of shares. And that's why this sentence in paragraph 11 refers to the fact that they are actually securities. And the reason for that is because it's not actually land and it's not actually the building, but you are being assigned stocks in a corporation, otherwise known as securities. And by virtue of your ownership of those stocks, of those specific stocks, you are permanently assigned a living space, perhaps a parking space in that cooperative. So it's included in what we discuss about real estate in BC law. So I just wanted to cover that. When we're talking about standard agency is the form of representation that DC looks to when we're talking about buyer agency or listing agency. It is the full scope of protection of the client relationship in terms of how we conduct ourselves with the client. And so that's where the definition comes in. As a standard agent, we owe the full degree of loyalties to our clients unless we are in a dual agency situation, which is a little bit reduced. So when we have a listing contract in paragraph 14 here, that is simply the document that a seller engages with a licensee to have representation, just like the buyer agency has one. And that's kind of where that is. So I want to go ahead and shift gears here. And we're going to eliminate this for a second. And we're going to go cover some documents. And let's first go to, we're going to look at this document right now. So how does all this work together? And why is my computer not working? All right. So how do all these elements that we just talked about fit together? Well, this is a document that is produced by the city, by the District of Columbia, and it is used to disclose the nature of your relationship when you do not represent the client. So remembering that we represent a client when we have a contractual agreement with the client that is signed by both parties, right? So that's a client. When we have a customer, we don't have that agreement. So when we don't have an agreement with somebody, and let's say that somebody called me on a listing that I have, and they said, I don't want a buyer agency agreement, but I want you to show me 123 Main Street. Then what I would be required to do here is I would be required to disclose to them that I would be required to disclose to them the nature of my relationship to them as a customer. So this first sentence goes into here saying that prior to providing specific real estate assistance, and that would mean like showing them the real estate, the District of Columbia law requires that a licensee disclose to any party who the licensee does not represent, and in that case, that would be a customer, the identity of the party to the proposed transaction, which the licensee does represent. So in the case that I was describing here a minute ago, I do represent the listing agent. I mean, I do represent the seller as the listing agent. So, and this notice is delivered to the customer, potential buyer. Even though a licensee may not represent you, the licensee must still treat you honestly in the transaction. So again, we're talking about the honesty that a customer relationship gets versus the fiduciary loyalties that are owed to a client. So I have to go ahead and disclose that. So in this case situation, we would be checking the box here that says buyer. And then I would be putting my information in my license and my brokerage information here. And then the licensee and brokerage firm named above represent the following party in the real estate transactions. So I would be checking the box sellers. And then here I would be having the client, the buyer, customer, sign and date on the lines below, if it's 2 people or whatever. If you had more than 2 people, you could squeeze them in and do that. So this part of it is what is required. And I need to have given this to that person who is the customer before I ever do any kind of service to assist that client, that customer, excuse me. So even before I go into the property with that customer, I need to have prepared this and presented this document to that customer and had them sign this. Now, if we look at the top of the form here, this notice is required by law and is not a contract. This disclosure does not create a brokerage relationship. So this is just a notice and it is a disclosure, and it is intended to make the person that we are working with, the customer, informed about who we represent as an agent. So if you as the buyer tell me as the listing agent in this situation, customer relationship, that you would be willing to pay, $1 million for this $500,000 property, I would be obligated to tell that information to my seller because I owe my seller a higher level of service than I owe to you as the customer. All right, so I just wanted to kind of use that as an example to illustrate that. So the goal here for me as a licensee is to present this form to you and to have you sign this to acknowledge it. However, the law does recognize that some people will be leery about signing anything, and therefore the law allows me as the licensee to be able to enter your name, if you as the customer, I would enter your name as name of person. And then I certify that on this date, as the real estate agent, I have delivered a copy of this disclosure to the persons identified above. And therefore, I would go ahead and sign my name here and date it. And I'm attesting to the fact that I delivered this to the agent, to the customer, but they were not willing to sign for it. So you either need a signature here in this section, or you need to sign it here yourself, as attesting to the fact that you did that. And we'd better make sure that if you are in fact signing it here down below, that in fact you really did present it. We don't want to be in the situation where you're signing your name there and you did not actually present this document, because that would be a violation of the law. So that's the use of this. This informs everybody. And once we've done that, then we can proceed into the building and I can show the property. Now, keep in mind, when I'm showing the property to a customer at this point, I'm doing it in a way that protects my seller's interests, and I'm advising my seller, I'm advising this customer on everything that my seller wants to see in a contract. And we're doing that. We're not guiding, we're not coaching, we're not and we're not suggesting anything to the customer about things that they can add. We're simply putting in what the seller wants to see. The list price, exactly as it's listed, and all of the terms. Now, because I am obligated to be honest to the customer, I do have to disclose material defects and material situations that do apply to the situation. But I don't have to volunteer other things. If let's say that my seller has indicated to me that they're willing to accept the VA and FHA loan, I don't have to volunteer that to my customer. If the seller has told me that they are willing to entertain an offer that contains a home inspection, I don't necessarily volunteer that to my customer. But so there are limits to how we engage here. So I just wanted to make sure that that's kind of where we are. Next thing that we're going to cover here is the consent for dual representation. So this document here discusses what we were talking about a little bit earlier about designated representation and dual representation. So remember, designated representation is the company represents the buyer and the seller in both transactions. And excuse me, the company represents the buyer and the seller in the same transaction. And so the company has loyalties to both of them, but the individual agents are designated agents or designated representatives. And the seller's agent has the loyalties to the seller. The buyer's agent has loyalties to the buyer. And the two can't reveal privileged information about the other about their respective parties, but they do work together to make a deal to make a deal happen. So if you have questions about how to manage and navigate through that, you should talk to your managing broker. But that's kind of the nature of the way designated representation works. So for the purposes of this discussion, designated representation in DC and in Virginia is the same thing as what dual agency is in Maryland. They just use different phrases for that. So in designated representation in DC, there's a trifecta of persons. There's the buyer, the broker, and the seller. And the seller is represented by their agent who works for the broker. The buyer is represented by the buyer's agent who works for the broker. And that's where that is. In a dual representation situation, it's more of a linear kind of a relationship. And so we've got the broker, the agent in the middle of the transaction, and then we've got the buyer on one side and the seller on the other side. I have loyalty obligations. I have fiduciary obligations to both sides, but I cannot reveal privileged information to each of the respective other sides. So this basically discusses that, and we are simply going to use this form to acknowledge that we are agreeing to the fact that there is dual agency or there is designated agency, whichever applies, if it applies. In most transactions where we have a situation where I am with ABC company and you are with 123, or there's another agent that is with 123 company, dual agency and designated agency do not apply. So that's basically, in a nutshell, the agency relationships in DC. There are other complications and other deeper subjects into this, but that's the basic gist of it. And I just wanted to give you this brief outline so that it's a little bit more clear, hopefully, as to where the loyalties and liabilities are. So if you have any questions, please reach out to your managing broker, or you may reach out to me myself, ADB@goodvibehomes.com. and I'd be happy to answer any general questions that you have. Again, I am not an attorney. I'm simply a broker with 26 years of experience in the industry, licensed in DC, Maryland, and Virginia. And so my guidance and lesson here today is strictly talking about my experience. I am not an attorney giving legal advice. Thanks and have a great day. We hope to share with you some more tidbits of information and look forward to our further discussions. All right, take care. Bye.